Corporation or LLC is one of the first decisions many Okmulgee business owners face when starting a new company, buying an existing business, bringing in partners, or trying to protect personal assets. The right choice depends on how the business will operate, how it will be taxed, how many owners are involved, how profits will be distributed, and how much formality the owners are willing to maintain. Both corporations and limited liability companies can provide liability protection when properly formed and operated. However, they are not the same. Each structure has different management rules, ownership concepts, tax options, record-keeping expectations, and long-term planning issues. Why business structure matters. Choosing a business structure affects more than paperwork. It can affect personal liability, taxes, banking, contracts, ownership rights, management authority, succession planning, investor relationships, and what happens if the owners disagree. If you operate without a formal entity, you may be exposing your personal assets to business debts, lawsuits, contract claims, and other liabilities. Forming an LLC or corporation can help create a separation between the business and the individual owners, but that protection depends on correctly forming the entity and treating it as a separate legal entity. What is an LLC? An LLC, or limited liability company, is a flexible business entity commonly used by small businesses. The owners of an LLC are called members. An LLC may have one owner or multiple owners. It may be managed directly by its members or by appointed managers. Many Oklahoma small businesses choose an LLC because it is flexible and usually involves fewer formalities than a corporation. An LLC can be useful for local service businesses, contractors, real estate businesses, family businesses, professional operations, retail businesses, and many other small business models. What is a corporation? A corporation is a more formal business entity. The owners are shareholders. A corporation usually has directors who oversee major decisions and officers who handle daily operations. Corporations often use bylaws, shareholder agreements, board resolutions, meeting minutes, stock records, and other formal documents. Corporations may be useful when a business expects to raise money from investors, issue stock, create multiple ownership classes, or eventually sell shares. They can also be appropriate for businesses that want a more traditional structure with clear separation between shareholders, directors, and officers. Liability protection. Both LLCs and corporations can provide liability protection. This means the owners are generally not personally responsible for ordinary business debts and obligations solely because they own the company. However, liability protection is not absolute. Owners may still be personally liable if they personally guarantee a debt, commit fraud, mix personal and business money, fail to follow required formalities, undercapitalize the business, misuse the entity, or personally participate in wrongful conduct. A business entity is a shield, not a license to ignore legal obligations. Management differences. LLCs usually offer more flexible management. The members can run the business themselves or appoint managers. The operating agreement can define voting rights, profit distributions, buyout rights, duties, authority, and what happens if a member leaves or dies. Corporations are more structured. Shareholders own the corporation, directors govern major decisions, and officers manage daily operations. This structure may be helpful for larger businesses, investor-backed companies, or companies that need formal governance. For a small business with only one or two owners, however, a corporation may feel more formal than necessary. Tax considerations. Tax treatment is one of the most important reasons to speak with both an attorney and a tax professional before choosing an entity. An LLC is often treated as a pass-through entity for tax purposes unless a different tax election is made. A corporation may be taxed as a C corporation or may qualify for S corporation tax treatment if the legal requirements are met. The best tax choice depends on income, payroll, distributions, number of owners, type of business, employee structure, reinvestment plans, and long-term goals. The legal entity and the tax election are related, but they are not always the same thing. For example, an LLC may elect certain tax treatment while remaining an LLC under state law. Recordkeeping and formalities. Corporations generally require more formal recordkeeping. They should maintain bylaws, stock records, shareholder minutes, director minutes, resolutions, and other corporate documents. Failure to maintain corporate formalities can create problems later, especially if a dispute arises or someone challenges liability protection. LLCs usually require fewer formalities, but they still need good records. An LLC should have an operating agreement, separate bank account, clear accounting, ownership records, written major decisions, and properly signed contracts. Even a single-member LLC should be treated as a separate business. Ownership disputes. When more than one person owns a business, the governing documents are extremely important. Many business disputes happen because friends, family members, spouses, or partners start a company without clearly defining authority, ownership percentages, profit distributions, responsibilities, buyout rights, and exit rules. An LLC operating agreement or corporate shareholder agreement can reduce future disputes by addressing these issues in writing. This is especially important for Okmulgee businesses with multiple owners or family involvement. Raising money or bringing in investors. If the business plans to seek outside investment, a corporation may sometimes be the better structure. Investors often understand corporate stock, voting rights, preferred shares, and board control. A corporation can also provide a more familiar structure for future expansion. However, many local businesses do not need that level of investor structure. For many owner-operated businesses, an LLC may provide enough flexibility without the additional corporate formalities. Real estate and asset protection. LLCs are commonly used for real estate ownership, rental property, and asset holding businesses. An LLC can help separate one business or property from the owner's personal assets. In some cases, business owners may use separate entities for separate properties or business operations. This type of planning should be done carefully. Insurance, financing, taxes, leases, deeds, operating agreements, and liability risks must be reviewed before transferring property or starting operations. Which is better for an Okmulgee business? An LLC may be better if you want flexibility, simpler management, pass-through tax treatment, fewer formalities, and a practical structure for a small or closely held business. A corporation may be better if you plan to raise investors, issue stock, create a more formal management structure, or build a company that may eventually need corporate governance. There is no one-size-fits-all answer. The best structure depends on the type of business, number of owners, tax goals, liability concerns, financing needs, future sale plans, and how the owners want to make decisions. Do not forget contracts, licenses, and insurance. Forming an LLC or corporation is only one part of starting a business. You may also need contracts, leases, employment documents, independent contractor agreements, customer terms, insurance, tax accounts, permits, licenses, and bookkeeping systems. A properly formed entity helps, but it does not replace good contracts or adequate insurance. Business owners should use all available tools to reduce risk. If you are deciding whether to set up your business as a corporation or LLC in Okmulgee, speak with an Oklahoma business formation attorney before filing paperwork.